about
So
habitual
would
drunkards is
you
relevant.
argue that it's okay to impose a ban on homeless people who are not drug addicts, but just merely homeless? Because vagabonds?
For Second Amendment purposes, no, we don't think so, and here's the difference.
And why is that?
Yes, I think the difference, two things. One is the point with respect to the specific application here, and two is a methodological point about Rahimi, I think. So here's the reasons. Being homeless is not itself a crime. Being homeless is not, at least in many, there are things additional to it for due process purposes. It is not unlike illegal drug usage, something associated with the public safety concerns historically. There is not a robust post-ratification history the same way. These are the kind of constraints you'd look at. On top of that,
the danger of habitual alcohol users was not merely the fact that they were using an intoxicating substance. The way habitual was defined was that the state of intoxication didn't permit you to have a regular life. All the definitions around habitual alcoholics centered around not merely taking the drug, but the potential effect it had on you because you couldn't control it and would continue to use it. You were acting responsibly towards your family. You were sleeping in the streets. You were doing other things that showed that it incapacitated you. Now, it's hard for me to see how, given that drugs affect, there are different kinds of drugs with different kinds of effects, different kinds of duration. We have the illegal ambient user who shouldn't be using the sleeping drug but is. We have a marijuana user that you say regular is defined by 2 or 3 or every other day, but how about the marijuana user who uses it only 1 day a week and not in their home where the gun is? I mean, there was a definition and a situation with habitual alcoholic users that's different than this.
so 2 points. One with respect to the historical definition of habitual drunkards, and two with respect to why I think that 922G3 is more tailored and easier to justify than modern day regulations. Habitual drunkards as a category were defined certainly for civil commitment and vagrancy purposes. There were no individualized dangerousness findings. It was a sort of judgment made often by magistrates or justices of the peace as to whether someone's conduct was frequent and putting them in the status of a drunkard. So habitual did mean frequent or regular. The drunkard piece is what does the work, I think, in a lot of your questions with respect to the level of intoxication. Second, why I think it's not a problem that there is translation of that level of intoxication for habitual drunkards to illegal drug users here. I think 922G3 is a lot more tailored. There's no like founding era breathalyzers to tell you exactly how intoxicating things are. For 922G3, what's happening is you have, first of all, a restriction that is tailored and temporary and less restrictive because it is tailored to how often you're using it within your control.
Well,